People don't understand. It's easy to get arrested. It's hard to go home. I like to describe it as I play in the major leagues. To be perfectly honest, sometimes I hate it. Sometimes I love it. This is my purpose. I had one client brought in for questioning on a shooting. He confesses to a murder that the police didn't even know nothing about.
That's just crazy.
That's a mythological culture that's been spread through the black community. Everybody tells on themselves. Everybody snitching. Don't tell me how to practice law because you didn't watch Law and Order or some jailhouse lawyer telling you what you can do, but he in jail with you. They even called him to the stand, played his video interrogation with the police, played it for him. He watched it and then told him, I don't remember saying any of it.
He like, what's his name in the YSL trial, Woody?
Because he'll be doing the trial and I'm still trying to figure out how am I going to get this nigga? I don't have a clue. And God opened the door and make a way. I always pray before I go to court.
I think it goes without saying, the job of a public defender is much more difficult than the job of a prosecutor.
If you hate losing, you're going to do great legal work.
Welcome to the Iron Gavel. I'm Chris Washington, a criminal defense attorney with over 17 years of experience. And today we explore a gripping tale of justice, a story where our hero faced almost insurmountable odds, but emerged stronger through a strategic defense. Let's uncover the truth together. The hero in the story is not me. It's none other than attorney Chris LaCour. He found himself entangled in a complex double homicide case which carried a potential sentence of life without parole for his client if found guilty. Wrongly accused, his client's entire world was turned upside down overnight. The stakes were incredibly high, and we will show you step by step how the case unfolded. But first, let's learn a little bit about our hero. So, Chris.
Yeah.
Can you tell us a little bit about yourself and your background?
I'm originally from Alexandria, Louisiana, born and raised. Graduate of Peabody Magnet High and attended D Southern University, grad school and law school. And I graduated law school in 2009. I passed the bar in 2010, and I've been practicing law ever since. I've done a little bit of everything. I hung my shingle out and I just went straight to work. I've done everything from family law, successions, criminal law, personal injury, munitions. I've just about done it all. Administrative hearings, both at the state and federal level, practiced in federal court. I've done a little bit of everything, but maybe in the last 7 to 8 years, it's mostly been criminal law. And that's what I've been doing. And as of since 2021, I was working 2 public defender jobs and private practice, but I ended up the head defender in one parish or county in other states. That's what they call them. Came to me and said, "Hey, what can I do to get you just to work for me? And I only want you to work cases that are life in prison." And so that's what I've been doing since 21. So that's mostly murders, first degree rapes, aggravated kidnappings. Those are the ones I think of right off top hand. Life in prison without parole.
What inspired you to become a criminal defense attorney?
I'll try to keep it short and sweet. I was in grad school and I was thinking about becoming a college professor. Just for me, I just felt like people's passion for learning, if it's not the same as mine, I didn't know if I could teach people. So I was like, well, how can I help people make money and still kind of have an academic pursuit? And I fell on the law. So after grad school, I ended up in law school. But honestly, it wasn't until maybe after I became a lawyer and thought about it. What really should have inspired me to be a lawyer when I was 17, me and some friends got pulled over and we got arrested, and we were in the back of the police car on the side of the highway. And somehow, I like to think I had a gift for gab, and I talked our way. Not only did we get out of the back of the police car, we were uncuffed, allowed to go home. Now the officer did call our mothers because we were 17 at the time, but I did get a citation for open container, and I had to go to court, and it was a mayor's court where the mayor was the judge, and he handled small citations. So I had to go in there for that at 17, and I made my argument to the mayor of the little court there in the little town, and he dismissed the citation. And so that probably really should inspire me, but my inspiration didn't come till much later.
I understand. So, how would you describe what you do on a day to day basis in a few sentences?
I like to describe it as I play in the major leagues. I'm a trial attorney. I haven't had as many civil trials. With custody cases, you have rule hearings, and it's almost like a mini trial. But I haven't had any just straight up civil trials. I have filed civil suits. Oh, I take that back. I had one civil trial, but most of my trials are in criminal court. My very first criminal trial was in federal court, actually, which was pretty frightening.
I bet. That's tough.
Man, I got through it really good. I was by myself. What made it okay was that the prosecutors were green too, just like me. But what was funny was they had a senior AUSA prosecutor behind them coaching them. Like they was taking time out. Literally, it was weird. And he would coach them and they would come back because they couldn't ask a direct examination to save their life. They kept leading the witnesses, and all I kept doing was objecting and objecting. And the judge finally had to call a sidebar, and he was like, "Man, you have to ask a question. You can't testify for the witnesses." But we were all new at it, and I almost won until the DEA chemist got on the stand and said what he tested was marijuana. Thinking back on it though, if I was a little more seasoned, I think I could have attacked him better. But it was my first trial, and I had did really good up until he said, "Well, no, the contraband was marijuana." My client was doing time in the federal penitentiary. He was charged with contraband, and so it made the case easy to try because he was like, "Man, I'm not taking no deal. I'm already doing 15 years." Well, it took pressure off to work something out. Even though I'm trying to push him, work it out, he's like, "No, I'm gonna have a trial." I'm like, "Okay." I did a motion to suppress in federal court and everything. First go around, I almost won my motion to suppress. So it was a good experience. And I think after that, my next really major trial was shooting in Marksville. You may be aware of that in 2016. And after that trial, it was a 2 week trial. And after that, man, I've just never looked back on trying cases. It's like what I do is almost bred into me. You try a case for 2 weeks and it'll change your life.
That's right. I think I told you earlier or a few days ago, I had two murder trials back to back.
Oh, man, that's brutal.
1 week murder trial in St. John the Baptist Parish, the next week a murder trial in Terrebonne Parish. And I enjoyed every minute of it, even though I was exhausted by the end of it. I wouldn't want it any other way.
That's right. We love what we do, man. If you're a trial attorney, it's in you. You know what I mean? It's almost like playing in the major leagues. You got high school ball, you got college ball, you got AAA, you got the major league. You know what I mean? It's levels to it. Everybody ain't cut for the job.
So I gotta ask you, Chris. I know you, so I know what kind of work you do. But a lot of people will question you because a lot of what you do is public defender work, and there's this perception in general about public defenders that gets cast on every lawyer that does public defense work, regardless as to their reputation, their commitment to the practice, and the results they get. So my question to you is, if somebody is coming to you, whether as an appointed case through the public defender or looking to hire you privately, what sets you apart from the stereotypes that exist for criminal defense lawyers in general and public defenders in general?
I win cases. I get results. I don't play. Look, man, like I say, I'm ready to step up to the plate and bat in at any moment. I can try cases in my sleep, man. I don't even do a trial notebook. It's all here. Now I know at some point I'm gonna get to an age where I'm not gonna be able to do that. When I first started, I'd have whole trial notebooks, but now it's to the point where I just make sure I know every detail of the case better than everybody else. I don't prepare my cross examination questions, my direct examination. As the defense attorney, you hardly ever calling anybody on direct exam. But even then, it's just like it comes natural, man. I know at some point I'm not gonna be able to do that mentally. I'm not gonna be able to keep up with them. But right now, I'm able to do that. My opening, my closing. I don't have to write nothing down. We talked about this. I equated to stand-up comedy, man. It's like you put your routine down, you might write it down, but when you go on stage,
You don't need it.
you freehand. You
That's
should
right.
know.
I have the same deal. Like, for example, jury selection, they put 14, 18. I had a trial in New Orleans. It was 35 people in the box. Before I get up to talk to them, I have everybody's name memorized.
Okay.
I'm calling them by their name. The prosecutor goes first, and they're typically up there fumbling through the papers, Mr. Smith, and all of that. So I lock the names in, and then I can roll. And the same is true. I do a little bit more like with my cross. I wouldn't write, "Would you agree the car is red?" I would just write on my list of questions. I might write "red car," and then I just know how to ask a leading question.
This is what I learned about cross for me. It's like I remember it was one trial and I was working on my cross examination and it was late at night and I'm like, I can't really cross him till I know what he gonna say. So I was just like, look, let me know his statement backwards and forward. And then based on what he tells the prosecutor, I'll know how to move forward. And once I started doing that, it made it things easy for me, I guess. I'm like, I just need to know his statement through and through. And then whatever they ask him, I'll be able to count on because I know the statement. And I'm gonna make sure I know it better than everybody.
What's one thing most people don't understand about what you do?
The toll it takes. It takes a heavy toll, man. Nobody really knows what I'm going through. I'm built that way. I come from a strong, hardworking people. I'm built to take more than most. And I also feel like God got a purpose on my life. And so, He's requiring more of me than maybe others. Even if I'm still a work in progress on the living that saved life and this work I'm doing, it's because of Him. And so I know more is expected of me. Sometimes, to be perfectly honest, sometimes I hate it. Sometimes I love it. This is my purpose. I can't be like Jonah running from the message he was supposed to bring to the people. You know what I mean? I have to meet it head on. Now, I do tell people as soon as that exit off this highway presents itself, I will take it because it takes a heavy, it really does.
It takes a huge toll. I tell people all the time, it pulls you away from things you enjoy doing. You miss vacations. You miss time with your kids. You miss time with family. Like all of that.
This is the fact that your brain always on. You can't turn off.
You dream about your cases. I dream about them all the time.
No, I don't dream about them. They prevent me from going to sleep. Word. And when you think you're gonna win, man, look, I've learned to keep myself, stay even keeled throughout cases. Cause bro, the ones you think you're supposed to win, you'll lose. The ones you're supposed to lose, you'll win. And it'll have you on the emotional roller coaster. Oh my God, man. It takes a heavy toll. And so, most people jobs, once they leave work, they ain't thinking about work.
They ain't gotta think about nothing. They clock out at 5, and they ain't gotta think about that shit till they clock in the next morning.
I'm worried about if this man ever gonna come home again. Like I'm gambling with lives. I ain't gambling with money. It takes a heavy, heavy toll. Like me and you was talking on the phone. I was telling you, and you were saying, man, but the rush it gives, it's a rush to it. As much as it takes away, it gives me something that I can't get anywhere else. For that maximum enjoyment, you got to endure some real hardships. Yeah, they go hand in hand. No, it takes a real toll. There's some days I have to avoid going home right away, so I don't take it home. And then I get home later. And some nights when I get home, I may not get to even see the kids because they gone to bed already. But that's better than me snapping at them for something that has nothing to do with them. I realized too, from looking at all the autopsy stuff, all the dead bodies I've had to look at. I think I have some PTSD, but I haven't been diagnosed. I diagnosed myself. Now, look, I say all of this though. It sounds horrible, but I wouldn't trade it for the world. It's weird.
It's not weird to me. I wouldn't trade it either, even though it's quite stressful.
And I've developed a macabre sense of humor. I laugh at stuff that normal people wouldn't laugh at. And a lot of times I keep that to myself, but it's just like in those Iceberg Slim books where he talks about his bottom girl. And he knows she only got so many tricks in her. You know what I mean? Just like with these trials, I know people want to do this forever, but for me, I feel like to give it your best, you only got so many in you. While they in me and they good, I'm ready to give them to the people, but I only got so many in them because of the toll it takes. And one day, I'm gonna want to be able to just sit back and enjoy life and enjoy the fruits of my labor. I don't want to be one of them lawyers who died at his desk at 80 years old. Like I'm not looking to be practicing law at 80.
Walking into the court with a cane or a walker.
Unless my kids or grandkids follow in my footsteps and we have like a legacy firm or something, I get me being there guiding them, but trying to be in some courtroom or something, my time is now. So while it's my time, I want to excel. I want to be Michael Jordan in 96. I hate losing. So it don't matter if I'm being paid privately or I'm getting my check from the public defender's office. I don't like to lose. That's what people got to understand. If you're a good lawyer, it doesn't matter what you do. If you like to win, man, I'm giving it my all, man.
You've only paid me half my money. It's still my damn reputation. I'm still gonna show up.
I have several cases like that. But I'll tell the client, look, man, and most times my clients are in jail, so it's someone else paying the ticket. But if they don't finish paying, especially if I like the circumstances, I can win. I can get you home and build my reputation in business. Now, I don't gamble with people's lives. If I think the case isn't good, I'll tell them straight up, I think you should take a plea. You're gambling with your life. I go home. If you're willing to take the gamble, I'll give you everything I got. But just know if we lose, whose decision was it? As long as they can understand it's their decision to go to trial, man, I sleep like a baby. Yeah.
So today, I brought you on here. Big deal. You had a client that was facing a double homicide. So why do you think it's important for our audience to hear about this case and the facts around it?
Well, because people don't understand. It's easy to get arrested. It's hard to go home. My client sat in jail for almost 4 years waiting for trial. And people need to understand, people be like, well, they can't prove it. No, probable cause for arrest is a very low burden. But beyond the reasonable doubt at trial, is a higher burden. People don't understand how easy it is to get arrested. How I could just go to the police station, tell them you battered me, and they'll pull a warrant out for your arrest without discussing with you, getting your side of the story and trying to make a determination of who telling the truth first. No, if someone complains, they take the complaint. That's the probable cause, and you can be arrested. And on murder charges, even in rural communities or cities like I'm in, I consider the city I'm in a rural because it's only about 50,000 people here. This is not a very big city. Bonds are astronomically high and they don't match the income levels of people in the community I'm in and most rural communities. Like, when we watch TV and we see those bonds set at millions of dollars in Los Angeles and New York, that might make sense to you because it's a major metropolitan area. But guess what? They set them bonds high like that in rural areas too. And you could end up sitting in jail on $1 million bond. I don't know many people that live in Louisiana with $1 million worth of property or family that could get with a bondsman and meet at least a percentage of that obligation. I don't know many. So you get a high bond and you're liable to sit in jail for a very long time. And people don't understand they can indict you. They have to indict you within a certain amount of days from your arrest. And once you're indicted, man, the odds of you bonding out or getting a reduced bond is kind of slim and none. Most judges don't want to be the judge to let out someone who may go out there and kill someone else while they on bond or something for another murder. So no judge wants to be that judge. They can set the bonds ridiculously high. You may just sit there and sit and sit.
We're going to dive deep into that case. But before we go there, I want to know, how do you typically approach a case when a new client walks into your office?
First things first, I like to hear their side of the story. That's number one. Get all the information I can from them. And then it depends on where their case is at. If I can get the police file, because I think it's always three versions of a story: your clients, the police version, and then what the truth is. And so first I just try to assess what the client tell me, and if the client is honest and forthcoming and tell me everything, a lot of times that helps me assess, okay, what we can and can't do, how I will move forward. Now, if they already have their discovery packet from the state, that's a really big help, because then I could just read that and figure out if there's any relevant motions that can be filed. But if I don't have that, talk with the client. If they can afford to hire me and an investigator, try to get an investigator on it. Try to use my contacts in the police. Is weird. I'm a criminal defense attorney, but I've developed relationships with police officers. And now, like, I can call them and ask them for stuff, and sometimes they'll give it to me way ahead of time. So I try to use all of my resources at my fingertips, learn as much as I can. If the client can afford to hire me, great. And then once we get involved in the case, you have to wait till court proceedings begin before you can start filing motions or things like that to try to knock down the case.
What would you say are some of the most common mistakes clients make when they first get accused of a crime or arrested for a crime?
Think they can explain their way out of it to the cops.
What do you think the percentage is that actually works?
9 out of 10 tell the cops everything. This culture of no snitching is a fake culture. That's a mythological culture that's been spread through the black community. Everybody tells on themselves. Everybody snitching. And I don't think people understand. Let's say we're on a RICO in a federal case, and I don't really tell on nobody, but I take the plea deal. Technically, that's saying that whatever the government is saying is true about you and everybody else. So you don't never really have to tell on anyone specifically, because if you take a plea deal, it's acquiescing to what the government is saying. So technically, everybody's snitching on each other, even if you tell them or not. If you take a plea deal, that's accepting the government's version of the facts, is it not? I'm missing something. And so we always point out people, let me see your paperwork. I just think it's a bunch of bull. Bro, when I say they tell on themselves, I had one client brought in for questioning on a shooting. He confesses to a murder that the police didn't even know nothing about.
That's just crazy.
And the shooting. And you see, I'm lost for words. They tell the police the truth and then will lie to their lawyer. And I'll tell us, especially if you come in as a public defender, they'll tell you, you work for them, you work for the prosecutor. Well, you just told them everything anyway. Why would you lie?
You work for them more than I do.
You just told them all the truth. Then I come in there, you lying to me because I work for them. Now make it make sense.
What should people do when the police say, hey, I want to ask you a few questions about this shooting, this murder, this robbery? What should they do?
I normally tell people just say one word: lawyer or attorney. But what I would tell them is, I would probably ask them, well, do you have a warrant for my arrest? And if they say yes, tell them, well, you can go ahead and read me my rights. I want my lawyer. Don't talk to them. It's that simple. They're not your friend. Their only job is to arrest. There's been a very rare occasion where I told a client, yeah, go ahead, give a statement. Tell them everything. And you may not go to jail. And guess what? They didn't go to jail. But those are rare circumstances. Very, very rare circumstances.
Would you say even before doing that? Because I guess that's what a lot of people think. Even before, if it's a situation, one of those rare situations where you might say, you know what? You've told me what happened. Go ahead and tell the police. Should a person ever do that without consulting a lawyer first? Or should they always go out and consult a lawyer?
I would advise always ask a lawyer first. If you can. If you can. But there's been a rare occasion where I've had clients give a statement and they gave, without them realizing, they gave a perfect statement that matched all the elements of self-defense, how they described the shooting. I was like, this is beautiful. And his interrogation video was played at the trial, and it didn't bother me at all. Now, mind you, in that particular case, my client still got convicted of manslaughter, but I did a such great job, I guess, presenting my case. In sentencing, the judge only gave him 4 years on the manslaughter.
Wow, that is the lowest sentence I've ever heard of on a manslaughter.
Hey man, if somebody at your front door, uninvited, striking you in the face, and my client, he say, look, I shot him because I was in fear. I'm a coward. I've never fought. I've always, as an adult, had a weapon because I know I can't fight. Now, this was, my guy was big, like 6'4", 300 pounds. But man, his, between his interrogation and how powerful it was, and him on there, and he just was like, look, man, I am a scaredy cat. Always been, always have. I'm on. And you get struck in your own doorway.
Yeah, what are you supposed to do?
They matched every element of defense. He had a right to be there. He was struck.
No duty to retreat.
No duty to retreat. Even though his force wasn't the same, he was in reasonable fear of losing his life. Even if you may have not thought it, he was. That's how that one turned out. So
This double homicide we're going to talk about today, can you give us the backstory on it?
these two teenagers, one 17 and 19, a boy and a girl, went missing about 2021, if I'm not mistaken. They didn't really have any evidence. They found the bodies in a vacant lot. At the back of the lot was a wooded area, and that's where the bodies were found eventually. They were missing for about 3 weeks, so they find the bodies, but they didn't have any evidence. They were just searching in the area the kids were last seen. They were last seen, what was that, February 28th on a Sunday. The person who last seen them saw the two individuals who were deceased with two other teenagers, and they were armed with a AK-47. Now, mind you, about the only real evidence they found at the crime scene were shell casings, and the caliber of shell casings matched an AK-47 rifle. So that was really the evidence they had. And they found the bodies. 2 days later, or within a week, the detectives got a call from a gentleman who had been arrested a day or two after the bodies was discovered on an unrelated charge. And he claimed he had information about the murders. And upon him contacting police, he told the police that my client had admitted to committing the murders to him and ended up with a warrant for his arrest. And that's how the case began.
What I want you to do is tell us about your initial meeting with the client, any doubts or fears you had going into that initial meeting.
So let me be upfront on this one. He was a public defender case. As I mentioned earlier, I do all of the life without parole cases in Rapides Parish. So he got assigned to me as a murder case, as a public defender. And to admit, sometimes my job jades me because I see some of the same stuff over and over. And sometimes it takes a client to kind of, rock my bells a little bit to wake me up and kind of see a case for what it really is, or how bad it is, or how good it may be for him. So when I went into it, I was just like, oh, well, dude said you did it. I don't know what you want me to do with that. And he didn't like my response. And you know what? I thinking back on it, I could have responded better. It was a long day in court. I think I had too many on the docket. I was just like, let's get to the next one. But mind you, this was at the very beginning of the case. It was like his bond reduction or something. So the case didn't get really far. So I did his bond reduction. We had that first meeting. It did not go well. Every time we talked, he just was like, man, you're not listening to me. And fair enough, I probably wouldn't. But in the same breath, he was disrespecting me as a lawyer. He kept telling me I was a public defender. And we just on a bad footing. And he not respecting me, and I'm telling him his case is crap. Whatever. So about 3 months in, he fires me and hires a lawyer. He pays this lawyer a substantial amount of money. A lot of money. He fell short of paying the man all his money. So this lawyer was on the case for about 3 years, till about from 2021 to 2024. And then he withdrew out the case because he didn't get the rest of his money. If you can't afford to hire another lawyer, guess what? You get a public defender again. I became the man's lawyer again. And when I got the case, I said, you know what? I told myself, me and him gonna have to have a come to Jesus meeting because over those years, the other lawyer had the case. When he would come to court about the case, because I'm in court all the time anyway, I would hear him say stuff about the case. So I had kind of picked up a little bit that, the client actually might have had a decent case to win at trial and go home. So my opinion had changed from just hearing stuff in the court about it in the back where the lawyers meet. But I wasn't going for no more disrespect. This thing about me being a public defender, that irks my nerve, man. I don't tell you how to flip burgers or pave roads or work at a plant. I figure you an expert at that. Don't tell me how to practice law because you didn't watch Law and Order or some jailhouse lawyer telling you what you can do, but he in jail with you.
That's right. He can't help himself, but he can help you.
It's ridiculous. So we had to come to Jesus meeting. He apologized to me. I apologized to him. And he looked me in my eye and he said, man, I do not want a deal. I want a trial. And that was music to my ears. And so
That makes your job easier. You don't have to wonder if you wasting time prepping and
none of that. That was July of 24. The trial was set for December. And me and the prosecutor had an agreement. No matter what, we was trying that case in December. No more continuances. So I had a 6-month period to try the case. Now, what most people don't know is last year I was like, man, I'm kind of burnt out. So I was like, if I can avoid trying any cases, I will. But once that one came about, I was like, well, I know I'm gonna try this one. So if I can avoid trial on my other case, not avoid, but if we can get by without trial, continue trying to work something out on them, because all these people facing life, I would hate to just tee them up and a lot of them get found guilty. I'm great with time because in these type of cases, even though people want things to happen fast, time helps these hard cases, especially murder cases. Time helps. I was like, I'm going to give all my attention to this one trial, and that's what I was able to do. And so I that one trial got all of my attention. Once I got past everything that I knew wasn't gonna go to trial, man, I dove head in about mid October and we were doing some investigating. We was trying knocking down all their theories, filing motions.
tell me about some of the initial evidence presented by the prosecution and some of the problematic evidence for you defending your client.
They didn't have any physical evidence tying them to the case. They had no forensic evidence tying him to the case. They had no weapon tying him to the case, no confession. They really had nothing. The only thing they had was the jailhouse snitch saying my client told him he did it. So that was it. That was the only evidence. And what was crazy was when the guy gave his statement to police, it was about they found the bodies one day. The next day he was arrested on unrelated charges. About 5 days to 7 days later, that's when those detectives got to him. He was still withdrawing from fentanyl use. And so he goes in and give his statement. They playing the interrogation video. In it, he throwing up in the trash can while he talking to him, sick as a dog. And what was crazy is they asked him, well, why are you coming forward now? And in his statement, he literally tells them, because I'm in jail.
Wow.
And I was just like, nah, if they want to go to trial on this, let's giddy up, right? I reviewed that guy's statement, and I got to give credit to my client. He had 3 years to review these statements. So by the time I got back to him, he was like, look, this. And I looked at it and I said, boy, you sure got a point. So I focused on that. And then I started to notice things on my own. And I realized how much his statement contradict the evidence they actually found at the scene.
I tell clients that a lot. I have a lot of cases. You probably have one. So a lot of times they have way more time to look at some stuff than you do. And sometimes they see stuff that you don't see. A lot of times it's just like that we can't do anything with that from a legal standpoint, but there are times where the client will identify a nugget that the lawyer just misses. But we have to be open. We got to be open to it. A lot of times well, not me, and I know not you, but if the lawyer approaches it as the I'm the lawyer, I'm all knowing, that could be real problematic because clients can be quite insightful into their own case.
Sometimes I have to swallow my pride and realize, please, I have to tell myself mentally, listen to the person. They may actually have a point. But boy, is it hard to listen to them? Oh, Father. Especially if the client gets on your nerve. You be like, what this time, man? But, you have to fight through that. It's so easy, like I said, to get jaded at a job that you do. And you almost become a human lie detector test. Like, nobody can really lie to me. Like I always can tell when you're not being totally honest. It's frustrating. Oh my God. It just wears on me. Like sometimes I have to have a conversation and say, look, man, you can be one or two clients. You can be one that'll sit up in here and gonna BS me. And then I just try the case with what I know. And if something come up that you're not honest about, then it ain't nobody's fault but yours and I go home. Or you can tell me everything and me try to plan for it. Now, if you're gonna BS me, we can end our visit now. I can talk to the next guy, and I'll see you soon.
I tell them all the time, I say, look, I don't know how to deal with a lie in court. If you tell me a lie, we get egg on our face in the trial, I can't deal with that. Now, whatever the truth is, I can come up with a strategy to address it. But don't give me a lie. Don't try to sell me a lie hoping I'm going to sell it to the judge or the jury. That doesn't work.
I'm not filing no frivolous motions either. File a motion to suppress based on what? You tell me the point of law that I could file it on, I promise you it'd be filed tomorrow. But in this case, I filed a motion to suppress. Even though I wasn't successful, I did try. I thought he had a pretty decent chance to get it. I also filed some other motions in limine, and I won two of those, and I lost one.
I want to hear about all the motion to suppress. What were you trying to suppress?
I was trying to suppress the bodies. That was the only evidence. The only evidence was the bodies and what was found at the scene. And so the search went like this. They searching the general area, empty lots, woods, behind people houses, because they getting rumors of where the people may be. And apparently the last place they wanted to search was my client's stepmother's property. When I read the file, I didn't read in there where they got consent or had a warrant. But when they went on the property, they didn't find the bodies there. The cadaver dog went to the lot next door that was an empty lot with a wooded area at the back, and they found the bodies there. But if the search started on this property and it was illegal, then I was arguing all of it was illegal. But I lost because they testified that somebody was home and said, yes, they could go in the yard and search. So I lost right there. And I kind of halfway writing it, I knew I was going to lose it. But I was like, you know what? I'm going to go through with it anyway because I'm going to make them tell me where the consent was or the warrant to go there because I don't see it. It's not in the file. And then they produced a signed consent form, but then I was like, well, is that person the owner? It didn't get over with the judge. Motion and limines are tricky because you want to file them, but it almost will tip your hand to what you know that they may not know or what your strategy may be. So I kind of waited till like the Thursday before the Monday the trial was to start, and I filed them.
You filed three or did you file?
I filed three.
Okay, let's go through them.
First one I filed was the Jailhouse Snitch said that my client killed the people because that's where he hid his dope at, where the bodies were found. And he caught them lurking back there because he kept game cameras that would alert him if somebody was back there. And that he got alerted and had to go take care of it. So that's how he say my client told him he did it. But he said he kept dope back there where the bodies was found. But he also told the police he knew he kept dope back there because he supplied him with dope. Well, possessing that drugs, if there were any, and supplying him with drugs are different crimes from the murder. And if they were going to bring up these other crimes he may have committed that may be part of the murder, or they got to file a motion. They never filed a 404B motion. And so I was like, they've never given me notice. This is in the discovery. This can't come out of the trial because it'll prejudicial my client from getting a fair trial. And the judge agreed with me. First, he said it was noticed because they gave me the discovery, which I didn't agree with. It's only notice if he files the notice. I'm not upset because he still ruled for me because he said why I think he ruled for me was because even though the snitch said it, there was no other evidence in the case to corroborate him saying this. They didn't find any dope at the crime scene. They didn't find any drugs. They didn't find any drugs when they arrested my client. And my client didn't confess to anything. And they did no other investigation to confirm whether my client sold drugs or not. So the judge was like, we got to keep that out because that's all in the snitch statement. So they had to blot out that part of his statement and not play that part for the jury, which I think worked in my favor. We almost had a mishap because one juror got the unedited copy when they passed out the transcript of the statement to the jury to follow along with the video because the video was of low quality. They forgot to blot it out in one of the statements, and one of the jurors read it. But thankfully, she didn't tell the other jurors. We dismissed her, and the alternate moved in her place. I filed another one because the cops theorized that a hole that they found dug up on a property that was like a quarter of a mile away was where my client and the snitch were going to move the bodies to. Apparently, the snitch told the police that my client called him and asked him to help him bury a dead horse, and he pay him $100. But when they get back there to where the dead horse is supposed to be, it's the two dead bodies. And so it was this whole big thing. They was always asking the snitch was, did he want you to help him move the bodies? But he told the police we didn't go back there with any shovels or a tarp. And who's gonna move probably a animal that weighs 1,000 pounds? Just two men? That doesn't even make sense. A quarter of a mile down the road. Anyway, they find this hole at my client's sister house who lives down the road. They do keep horses, and there was a horse pen. And there was a hole somebody had dug behind it. So they gathered bottles and stuff from all around the hole trying to collect DNA. And it all came back inconclusive. And the snitch never said we were going to move the bodies there. And I was just like, this is just a theory that's never been proven. All this is going to do is prejudice my client from getting a fair trial. They haven't proven that this is where my client was going to move these bodies to. They shouldn't get to tell the jury this theory that they've come up with. The judge agreed. And then I filed one more motion in limine to prevent police conduct being used to bring in hearsay. But I withdrew that motion because the prosecutor was like, oh, I don't intend to try to use the cops to get in hearsay testimony. And we had trials before in the past. He's a man of his words. I withdrew that motion. But I really think them not hearing about the drugs helped. The hole behind the horse pen, they didn't really have no evidence to prove that. But the drugs, I was worried about that. I really was. So I'm glad that didn't come in. Because if they would have thought drugs was involved, then they might have would have believed him, even though he on the video clearly withdrawn from heroin at his interrogation video. Or fentanyl, I'm sorry. He was on fentanyl.
They put fentanyl in everything now. Weed, heroin, these fake pills, it all got fentanyl in it.
Apparently, when he came to jail, he was high on fentanyl and methamphetamines. On meth. Now, his withdrawal from meth only lasted about 3 days. But it was a week later and he was still withdrawing from the fentanyl, and it was bad. And withdrawing from that stuff, your body becomes dependent on it. Some people have to take it for the rest of their lives. Once their body can't live without it, it'll kill you. So he was having bad withdrawals. I had the jail calls. Chris, when I say I was ready to eat him alive on the stand, I had all my stuff lined up. I even had one jail call where he told his mama that they was accusing him of doing it. Mind you, he had just come from the police station telling them my client did it. He just lying to everybody. I was ready to get him. I guess he didn't want nobody to think he was a snitch. So he telling his mama, yeah, they brought me in there asking me about them people. Now, mind you, she not even asking him about this. But he just brings it up. That's how you know when a snitch trying to cover their tracks before the word hit the street. Yeah, mama, they brought me in there asking me, telling me, they saying I got something to do with this. And she kept asking him, who is they? It's like, boy, the streets ain't talking about you. His mama told him, boy, the streets ain't talking about you. Ain't nobody said you did that. What are you talking about?
So tell me about his testimony. He's the star witness, I guess. He is the evidence against your client, right?
Yeah, I would say, well, we started off picking a good jury, which was great. We had a diverse jury of men, women, black, white. So I'm happy about the jury. You know, prosecutors play that dirty trick of getting rid of black folks, especially when your client black. And they claim it ain't intentional, but you know it. Especially if you get a jury and then you backstrike a few, boy, they always go for the black jurors.
How do you combat that? Because I know if they're trying to get rid of the black jurors or any minority or any protected class, really, how do you combat it? What do you do? What can you do?
Oh, it's called a Batson challenge. And you make it during while you picking the jury. But you know, a good seasoned prosecutor, you know what he does. He'll get rid of 2, 3 in a row. You know, you got to get up to about 4, 5 in a row before you can raise the challenge. They'll get to 2 or 3, and then they'll get rid of a white person, and then go right back to the black people or Hispanic people or a person who's been in prison before or anybody they think won't agree with a prosecutor. But the prosecutor I had, he's not only a good lawyer, he's a gentleman. When we try cases against each other, it's just about picking the best juror. So we had a good jury. Really, the only evidence at trial was the snitch. That was it. That's the only thing I had to prepare for was the snitch. And what was crazy was when it was his time to testify. So we put on the crime scene investigator first, who does the crime scene. I'm not gonna say I made him look like a fool, but when you got a crime scene investigator, the one who takes the pictures of the crime scene say he never really looked at the bodies, but he took the pictures. That's what this investigator told me. They put their star witness on. Unbeknownst to me, the star witness had already told the prosecution that if they put him on the stand, he was going to testify that he didn't remember saying anything in his statement.
Was he incarcerated at the time he testified?
No. So he thought giving the statement would get him out of jail, and it didn't. And this is all in his jail calls. As soon as he realized snitching on my client wouldn't get him out of jail, and they wasn't gonna give him no immunity or let him go home, he pivoted with the sheriff's department. And the sheriff's department has a program that'll send you to rehab if you are at the jail and you clearly an addict and you withdrawn, they'll send you to rehab. It's a good program, and if you complete it, it may lead to dismissal of your drug charges. And so he took advantage of that, got clean. So in the 3 years my client waiting for trial, the man had then got clean, moved away, got married, totally changed his life. I guess he didn't want to come back and deal with it. And I think part of it was because him telling what he told didn't even do nothing for him. I think that was another reluctance to come back and testify because it didn't get him no help. But apparently, like I said, he had already told the state he was going to flop on this testimony. And so they called him to the stand. And mind you, for 2 nights in a row leading up to that, I'm up all night planning how I'm gonna attack him. You know, cross examination is the highlight of the trial for us, man. I had already had it in my mind he wasn't gonna be up there less than 2 hours. I was gonna destroy him. When I was done with him, he was gonna wish he had went home to his mama. The prosecutor called him as they witness. Well, you know, they asked him his name and stuff, and then they was like, "Do you recall making a statement on such and such date?" I don't remember. This man said this for 2 days straight. Every question they asked him, I don't remember. I don't remember. They treated their own witness as a hostile witness for 2 days, man. They even called him to the stand, played his video interrogation with the police, played it for him. He watched it and then told him, I don't remember saying any of it.
He like what's his name in the YSL trial, Woody.
Hey, you know what was funny? One alternate replaced one juror, and the other alternate got dismissed because they don't get the vote. And when I got to talk to her how she would have voted, of course she said not guilty, but she said I wanted to bring that up in my closing, but my jury was a little older. I don't think they would have caught the reference. But the alternate was like, yeah, that's all I was thinking up there was YSL Woody. Like, why you even up here? Up here lying. I was like, it was just it was crazy, man. 2 days he did that.
Tell me how you cross examine A witness who, I guess, essentially doesn't lay a finger on your client, doesn't hurt your client. You were relishing that opportunity to cross him. So what happened to the actual cross?
Well, what happened was all the stuff I needed to destroy him on, his statement, which was essentially his statement, he destroyed himself by saying, I don't remember saying that. I realized I did want to get out the fact that he was withdrawn from fentanyl and basically told the police, I'm coming forward because I'm in jail. I thought that was important for the jury to know that one fact. And so I think I asked him a total of maybe like 5 or 6 questions. I was like, if you don't remember your statement, I can't cross examine you about it, can I? He was like, well, I guess not. I was like, well, at the time, wasn't you were in jail? You were addicted to fentanyl. You were having withdrawals. He admitted to all of that. I say, and didn't you tell the cops? And you were sick when you was given that. You know, they had seen the video. He clearly looked sick. He admitted to all that. And then I was like, you told him you came forward because you were in jail, right? I say, and you'd have did anything to get out of jail, including lying on my client. Now, of course, he didn't admit to that, but that was all I needed. I went and sat down, prove my point. And that's the great thing about that's hard when you first start trying cases, but as you get better at it, you know how to drop a mic and go sit down.
When you're young, if you got a 5-page outline, you feel like you need to go through it. But after a few years of doing it, I mean, really having trials, you're just like, I don't have any questions. This witness hasn't laid a hand on my client.
Pathologist, unless it's something I really need to get out, I don't really be having any questions for the pathologist. If you can't hurt the client, but if I think you can help, and man, this is how I know I'm doing the Lord's work. A lot of times, things, you know how it is. You want to get something introduced, and you trying to figure out how I'm gonna do it. And then a witness, it's usually a state witness will say something or open the door to something. You like, oh, that's how I'm getting it in. It'll happen on the fly. Like I'll be strategizing about how can I get this in. And I know how to introduce evidence, but you got to lay a foundation. But a lot of times the witness will do something and I'll be like, oh, that's how I'm getting it in. Oh man. Cause he'll be doing the trial and I'm still trying to figure out how am I gonna get this in here? I don't have a clue. And God open the door and make a way. I always pray before I go to court for God to give my clients favor. I don't need any favor. I've been trained. I know what I'm doing. But every now and then we need a little divine intervention, my brother. I think you know that. Sometimes things happen and you be like, this may sound crazy to some people, but it only happened. God gotta be involved because I didn't do nothing.
It ain't me. I'm good, but I got limits as to what I can do.
I got some limits, man. I didn't have to do anything. As soon as he started saying, I don't remember, I grabbed my client. As we by the table, I'm like, boy, you going home. I'm whispering this in his ear. I'm trying to keep my composure, and I'm telling him keep his composure, but I couldn't keep mine. I'm like, man. And you know, winning a double homicide murder trial, man, that's not nothing that happens every day. You know what I mean?
That's rare.
That's rare, man. People don't understand that. And I've won some other cases where I'm like, people don't understand the gravity of what just happened. First degree rape cases. I've been first chair on one, second chair on another, and got dismissals. And people don't understand how hard that is, man.
Here in Louisiana, you and I know, but for the audience, what's the penalty for first degree rape?
Oh, life, murder, life.
Now, what does life mean in Louisiana?
Do they bury you on side the prison when you die? That's if somebody come claim your body, if your family still remember you. I hate that in Louisiana that the only in between murder with the life is manslaughter, which is 0 to 40. And just always at the high end. All these other states, they do have murders without parole possibility, but they also have murders with the possibility of parole. And I think we need to have a little leeway because every murder ain't a heinous, horrible crime. Sometimes homicides happen unintentionally. Even though we got negligent homicide, it still may be more than that. But this person may not need to do life. And even recently, in not this legislative session, but the last one, as soon as Landry came in, that special session, one representative introduced a bill to raise the penalty on negligent homicide to 20 years. And I'm like, we already got murder, which is life, manslaughter 0 to 40. So now on negligent, which I don't think it passed, thank God, but
That's ridiculous. I think the penalty for manslaughter is too much. In a lot of states, it's 15, 20 years, and ours is 40.
0 to 40 is too much latitude, man. Like you said, that manslaughter I got the 4 years on, that was rare. But I believe the only reason I was able to pull off that sentence was because of the fact the jury, I don't think understood that even though he killed him, self-defense applied. And I think the judge realized that from me putting on my case. It's the only reason he got the sentence he got. And like I said, it was one of the few times a client gave a statement, turned himself in, that I think actually helped him at trial, especially when it came time for sentencing.
Was this case a case where there was a lot of experts or private investigators you needed to go out and retain, or was it just attacking their witnesses?
The public defender office has an investigator, so I brought him in and told him exactly what I needed. But I didn't have to use him because everything I was going to get in through him, I got in through the police, which is great when a witness that's not yours brings in the testimony that you need. And so I didn't have to use him, but we went out there, photographed the area, made photographs. We went into the woods where the exact location of where the dead bodies was found. Now, mind you, the vacant lot where it was found, the front of the lot was an empty open field. The back of the lot was wooded. The snitch claimed that as soon as he got to the edge line between the field and the wood line, he could see the bodies, which I knew wasn't true. So we went out there and I had my investigator. We went into the woods. He stood where the bodies was. I went back to the wood line and took video of him talking. You clearly couldn't see him. But when the officer who had the cadaver dog and the other investigators testified, they testified that when they got to the wood line, you couldn't see the body. So I didn't need my investigator to do that. I don't want to beat a dead horse. I requested my client's cell phone records, but the carrier didn't have them. I was going to need an expert to maybe GPS coordinate his location if it would help me, but I couldn't get any records. So other than that, there was no real experts to engage because the only evidence was the testimony of one witness. So there was no ballistics to combat, no DNA to combat, no confession under duress, none of that stuff. It was just knocking down they one and only evidence was the witness, and to show how, I don't want to say how bad, but how lack of an investigation the police did once they got the answer to their question. Once they got a name of who did it, they stopped investigating, which was a mistake on their part.
So it sounds like they were ready to throw your client away, give him life without parole, based on the words of a somebody who was admittedly addicted to fentanyl.
At the time of giving the statement, yes. You know what the law is on the testimony of one witness. If believable, you can convict, but as long as it doesn't contradict the physical evidence. And the police didn't bother to determine whether his statement contradicted their physical evidence. I'm gonna give you one example. Both of the bodies had been decomposed for about 3 weeks or more. The snitch claimed he knew it was the kids who was missing, but he didn't know it, but he knew it because the kids was missing. So he kind of figured it was them. And then he said he recognized the young lady by her hairstyle. Now, mind you, the young lady was the snitch's little brother's sister. So the young lady who was deceased and the snitch had a brother in common. He hadn't even told his brother what he knew. So it was hard to believe him. But what he claimed was he recognized the girl from her hairstyle. But after 3 weeks, the hair had totally fallen off the scalp. It was just a scalp. Now, mind you, the bodies was discovered. He claimed my client took him out there 2 days before the bodies was discovered by police. So this the 16th, he saw the bodies. The police out there by the 18th. I'm sure that body was just as decomposed on the 18th as it was on the 16th. I got both investigators, the lead investigator and the crime scene investigator, say, well, look, if this is the female, where's the twist? Where's her hairstyle? Where's her hair? Her hair was on the ground. It had completely all fallen off. You couldn't tell what hairstyle she had. So did you corroborate what he said with what the evidence was? Clearly, him saying he recognized her by her twist didn't match what they saw at the crime scene, which was all the hair on the hood was gone, bald.
What about him, the snitch, for lack of better words? Was he investigated? If so, what was the result of that? If not, why wasn't he investigated?
They didn't investigate him. They just took him at his word, which is crazy.
Did you ask him about that? Like, hey, why didn't y'all look into him?
No, you know what I asked him about? I didn't really consider him a suspect because I just figured he was lying to get out of jail about everything. And everybody knew the kids was missing. He wasn't arrested till after the bodies was discovered. Of course, I'd say I know something to get out of jail. I just figured he was lying. I don't know why they took him at his word. I was really asking why didn't they investigate the two kids who was last seen with the deceased two kids carrying a weapon that matches the caliber of bullets found by the body? That's what I was asking. Wouldn't they make the most likely suspect the last people seen with them, and the four individuals have the same type of weapon that matches the caliber of shells found by the dead bodies, walking in the same community or the same neighborhood where the bodies was found, not far from there? And you know what they told me? That they questioned those other two teenagers, and when they denied that they had anything to do with it, they just stopped investigating.
Unless I'm missing something, they could have tested their DNA. They could have tested for their fingerprints. They could have done all these things to get to the source of who really killed these two people.
When I asked about the caliber shells and whether they had any forensic evidence on them to tie to anybody, they really didn't collect any real forensic evidence to try to tie to anybody. But I would tell you this, I would think it would be more probable cause to arrest them two than a snitch who tells them my client did it and you ain't got no other evidence. When you actually got an eyewitness who put these four people together with the same caliber weapon that killed the individuals. To me, that's more probable cause than a guy throwing up in your interrogation rooms. They didn't never found no game cameras. They never found no images on his phone from any game cameras. They never found any drugs. They never found any ammunition. They never found a weapon. The contradictions in his statement, I mean, it's just on and on and on, man. He said he immediately smelled the dead bodies. The man with the cadaver dog said, well, it smelled, but you couldn't smell the bodies till you got right there on them. He 10, 20, 30 feet away. Kudos to the lead detective because after the trial, he said, once I got my answer, I stopped doing more. He said I should have did more. You pointed out where I kind of dropped the ball at. Now, the next case, he probably going to be on his P's and Q's. Sometimes you have to go down every rabbit hole before you make a decision on who you're going to arrest. That tends to not happen. Once they think they know the answer, that's pretty much it. You're going to be arrested.
Tell me about the closing argument. It sounds like you had it pretty set up. I want to hear how you argued for a not guilty verdict.
So what I did was I'm starting to use visuals now. And so I did a PowerPoint that I used in my voir dire, but I only brought back like 2 or 3 slides from my voir dire to my closing to show them again, to empower them to make their own decision and not compromise a verdict or make a sympathy vote. And then what I did, it was so simple. I did a Word document. I made 2 columns. One column I put beyond a reasonable doubt. And then the top of the other column, I put reasonable doubt. And on the beyond reasonable doubt side, I put the state is proving their case beyond a reasonable doubt because this person said my client did it. That's the evidence. That's it. And then on reasonable doubt side, I listed all the contradictions I point out. And it was like a page and a half. I just showed them this. I say, now, if you believe this man, then you should convict. But I think you can find at least one piece of doubt here. With the list I just showed you. Mind you, none of y'all doubts have to be the same. That jury empowerment stuff, I think, really helped me, man. Empowering the jury to make their own and just kind of instilling that in them. Make your own decision. Make your own decision. Don't compromise. Alert the judge if somebody's bullying you, stuff like that. I know you well aware of that stuff, but this is the first time I really incorporated it into picking my jury. And I think it really helped. And man, they came back. I showed them this and I'm just like, if you can't agree with at least one of these reasonable doubts I've put up here, then I didn't do my job. Now, what surprised me is how long they went into deliberation. But I will tell you one other thing that'll make you laugh. When I asked the detective about whether the two kids they was last seen with the same kind of weapon that possibly killed them, why wasn't they the main suspects and why didn't you investigate them? And when the detective told me that because they said they wasn't involved and so he stopped investigating them, he said that, man, and one of the jurors bust out laughing like audibly, which that doesn't happen during a jury trial. She bust out laughing because it just sounded, just because they told you they didn't do it.
It's an absurd position to take as detective to detect the crime.
And then I'll tell you another part that was just, this was a weird trial in a sense. So it's the end of like the third or fourth day, and the state said, well, we're going to rest. But then they were like, no, we're going to rest in the morning just in case we want to do something else. And we was like, cool. So when we got there the next morning, the prosecutor was like telling us, the court personnel and the judge and me, well, we're just gonna rest. We're not calling nobody. So the prosecutor stood up. He said, the state rests, Your Honor. One of the jurors, and this guy was a foreman on the jury. He was a pastor, and we was worried about him. But when the state rested, he looked at the prosecutor and say, you what? Out loud. It was weird. I guess he realized, man, y'all ain't done enough.
You've been resting the whole damn trial.
And I'll bring you back to this. In my closing, I used a story out the Bible that I had just heard in church like 2 weeks before the trial, but I had heard the story before because my mom had told it. It was about King Ahab and Jezebel and how they took a man's vineyard from him. And how they took it was Jezebel had two people go, and Ahab wanted his vineyard. And the man told him, well, no, you can't have my vineyard. This is part of my inheritance. I got this from my family. So Ahab goes back to the palace. He all upset. And Jezebel says, well, what's wrong with you? He tells her, well, look, I want the vineyard. He won't give it to me. She say, okay, don't worry about it. I'm going to take care of it. Now, mind you, I'm giving you the abridged version. She writes the town and tells them, look, I need y'all to hold the festival. I want you to put this man, honor him at the festival, but I'm going to send two people there to lie and say that this man has blasphemed against God, and then I want y'all to judge him and execute him. In so many words, I'm giving you the brief version. So they hold the celebration. The man is honored, but then they got these two liars at the feast who claims that he blasphemed God, and the crowd believed him, so they stoned him to death and killed him. And so, mind you, she sent the letter not by her name, but with the king's seal. So they thought it came from the king. And so I told this story to tell how someone lying on you can take your life and destroy you. Someone can lie on you and you can lose it all. I told that story specifically because that pastor was on it.
That's actually a powerful story. I think it's more powerful than the one I've used, and I'll look it up when I need it. The lady's name was Hannah or Savannah or something like that. And it was like around the time during the Quakers where judges would go around from town to town and they would be hosted in the home of a prominent family. In this case, there were two judges that went to this town and they both tried to sleep with the wife. And what happened was she was big into gardening. So they both went into the back. This is where the rule of sequestration comes from, which allows you to have all the witnesses kept out of the courtroom during the trial so you can, get fair testimony and they're not influenced by the other ones. So what happened was the two judges both tried to sleep with her. She declined both of them. And they said, well, if you're not going to sleep with us, we're going to say you slept with us anyway. So what happened, she was locked up, put in jail. She hired a lawyer, and her lawyer asked that the two judges not be allowed in the courtroom together during her trial. And so the way they won the case was she was a gardener, so there was this special, unique tree that she would primarily take care of. And the lawyer asked each judge individually, outside of the presence of the other judge, what kind of tree it was. They both described totally different trees. which proved that neither one of them had ever been to her garden. And that's where the rule of sequestration comes in with respect to keeping your witnesses apart.
Well, you just taught me a little history lesson right then. I didn't know where it came from, but you better use it when you go to trial because a lot of times witnesses, for example, during this trial, the lead detective had another detective do a warrant for him, an affidavit for the warrant. And that's all he did. So he hadn't been paying attention to the case. He just did that because he asked him. Well, when I called him to the stand, had him question about his affidavit that he submitted to the judge, man, the man was oblivious. He just did it because he was asked to. He never had reviewed it. It was horrible for him. I heard that after he got off the stand, he went out there and cussed the lead detective out like, man, don't you ever put me in this effing position again or whatever. I did this for you, but hey, I don't know if that's true. I just heard somebody say he told him that. But if you're gonna be filing something, if you're gonna be part of an investigation, at least know what you gonna be questioned about. I would think, at the very least, you know what I mean? Because I'm coming, and you know what's the good thing about being a lawyer? As long as I have, and probably you, I know it. When you probably first started practice, I was a pit bull with it. I want to latch on and not let go. But now I just beat him up with kindness. I take the Larry Bird approach. That's how I look at it now. I'm gonna just tell you what I'm gonna do. If you stop me, great. If you don't, great. That's the whole point of it. We playing the game, man. It's a battle of the minds.
Oh, I tell people all the time being mentally drained is way worse than being physically drained. You can bounce back from that. Sometimes when you're mentally drained, the only solution is a break.
You can become a zombie if you don't take regular breaks, vacations. I've gotten better at that. At least twice a year now, I go somewhere. Few days, 3, 4, 5 days. You can never be gone too long, though. Unfortunately,
Tell me about your client's reaction when he heard the verdict read.
man started crying. Man, just imagine. And it got emotional a few times through the trial because I guess as the state realized how bad their case was because of the witness, they started offering me deals. They had went down all the way below 9. I think we had got to about 9 years to try to take a plea before a verdict. You know Chad Gio. Chad was my second chair.
Oh, yeah, I know Chad. We both from Evolve, so I see him a lot actually.
They throwing the plea deal. And so I'm telling the client, look, man, as your lawyer, I have to bring the plea to you. I can't not tell you, but it's whatever you tell me to do. And so we went back and forth a few times. And then finally he was just like, man, look, I didn't do nothing. I don't want to take a plea. And once he said that, I told Chad, look, if you figure out a plea deal between the prosecutor and talking to the client, great. I'm finna keep trying this case.
If you're in the heat of the battle, I tell people all this plea negotiation, it actually can knock you off your game. You got to stay focused on the trial.
Once he said, look, this is what I want, I said, cool. If y'all can figure it out, great, but we gonna keep going. So I appreciate Chad for being able to do that and that not take my attention. And my client, he was kind of there because he's like, well, if they give me something that'll time served and go home, yeah.
It's hard to walk away from that.
They just wouldn't do that. Quite honestly, this is just my opinion. They probably should have. At least they would have got a conviction because he was the worst kind of witness you can have, whether the prosecutor or the defense.
And they rode with him, try to take a man's life.
I would say this: if we was in a major metropolitan area, New Orleans, Houston, the case might have not got tried. But in a small area like this, you got families demanding justice. These cases gonna go to trial.
Based on what happened in this case, because it appears like they just went after your client with no evidence, what do you think should change in our criminal justice system?
I use this example when I'm picking a jury. I tell them, what's the difference between real life and what you see on TV, where real life gets it actually wrong and TV actually gets it right? I say, in Law and Order, they investigate every lead till they get their man. Even after they arrest the person, sometimes they keep investigating if some new evidence is developed or whatever. Where real life gets it wrong is that Like I said earlier, I can simply go to the police department, make a complaint against you, and that's it. They will put out a warrant for your arrest without any investigation, without talking to you, if you choose to talk to them. And you can just be arrested. It's easy to get arrested, it's hard to get out. So I would hope that in real life, police won't be so quick to just jump at the first answer they hear that they think solves their case. Because like I know, a lot of times they never have enough evidence to arrest you until most of our clients confess. They bring you in, they got something, but they like, if we can get the confession, we good. We signed, sealed, and delivered. And everybody goes in there and confess. If they would just shut up, even if they're arrested, they still better off if they would just shut up.
That's right.
I got one now. They like, oh, we want to talk to him about another murder. And I'm like, no, you're not. Y'all gonna have to prove that one. We're not giving a statement on that one. He's already talked to you about this other one, which he didn't admit to nothing in that. But if you think we finna just come in and admit to another one, no offense. I understand the family want closure, but they not gonna get it today.
That's your job. You got to protect your client. I really appreciate you coming on. This has been good, man. This has been better than good, actually.
I enjoy discussing my cases. For some reason, sometimes that's all I talk about. For some reason, us lawyers, when we get around, we talk about the very thing we claim we hate. I may call about just, hey man, what's up? Before you know it,
We're talking about a damn case.
talking about the case, man.
I know your office is in Ellick. Do you do stuff in surrounding parishes?
Man, I'll be everywhere. Vidalia, Harrisonburg, Gina, Jonesboro, Monroe. You know what? I want to get more cases in Lafayette area. Opelousas, Lafayette. I mean, I grew up in the summers going to St. Landry Parish. My grandmother's family is all from there. I got a bunch of cousins there. And I want to get in Lafayette more. My name is literally on the courthouse in Lafayette Parish.
Really?
My name means of the court. If you go look at, it's spelled in English and French on the courthouse. You will literally see LaCour on the courthouse. That's weird. When I was growing up, people were, oh, your name means the heart. It does not mean that. It's the heart in French is spelled a different way. My name literally means of the court. I'm literally doing, my profession is literally what my name is.
So if somebody wanted to get in touch with you, so, if they were facing a charge or they had a family member or friend facing a charge, what's the best way for them to reach out to you?
318-541-6103. I'm on Instagram, Facebook, TikTok, either as Chris LaCour or Christopher LaCour. Seeing my name is capitalized on social media. My email address is chrisklacour@yahoo.com and chrisklacour@gmail.com. And I'm not saying I got a big following, but I'm on social media. It's not hard to find me. But yeah, man, everywhere. Lake Charles. Oh, you know what? I want some cases in New Orleans for some reason. I heard it's a little chaotic down there. I would like to see what that chaos is about at least one good time.
It's total chaos. But I hear it's a great place to try cases. Honestly, Harry and I started doing a few conflict cases down there. Just because they try to move the cases are gonna go to trial. Anything to get more trials, even though trials are demanding and tough and time consuming, we still want to do more trials.
Like I know, as a private lawyer, you may go to trial every few years. It takes being a public defender to get the workload that'll allow you to be able to have cases. That's the reason why I do it. It keeps my skills sharp. Are there some bad public defenders? Yes. Just like there are bad prosecutors, just like there's a whole bunch of bad private attorneys out here lying to people, continuing cases forever and a day.
Waiting on the final best offer, the last best offer.
The Louisiana Robert Shapiro. You know what I mean? We trying cases, man. And so public defender helps to sharpen that skill, man. It's just so important, man.
I know you have other cases you've tried, got not guilty, or got dismissals. I may bring you on at a later date to talk about some of those. You got anything interesting coming up in the pipeline that'll be tried this year or next year?
Oh yeah, July. One up in Gina. Don't know how that was gonna go.
What's the charge?
Murder. I do conflict work for the seven. I guess the seven JDC is Catahoula and Concordia. As far as the public defender, he handles three parishes: LaSalle, Catahoula, Concordia. Derek Carson, a good guy, SULC alumni as well. But he got me on conflict cases out in them three parishes, only murders. And I got one in Gina, husband accused of killing his so I'm that one has me concerned a little bit. You know the history of that place. There is a racial dynamic, black husband, white wife. So I'm working on how I'm gonna get my voir dire done because you know who's gonna be asking them if they've ever said the N-word.
You gonna ask him?
This guy. Without hesitation. And how much you wanna bet? They tell me exactly what I need to know.
Yeah, they gonna tell you.
And you know, like I know, I always tell people when I ask about this stuff, it's not whether you say you've used it or not. I know the answer to that question. It's the context in your answer and how you say it and how nonchalant or how apologetic you are when you say, well, I don't use it anymore. Or if you say, yeah, I use it, that's going to let me know who I need to keep and who I need to let.
Gotta use a strike to get rid of them.
But yeah, that one for sure. I had one next month. But the prosecutor has offered my client a sweetheart plea deal. But I feel like I need to still put my subpoenas in tomorrow just in case for March 10th. Just in case.
You gonna have a trial during Mardi Gras.
The week after next, March 10th. I got enough time. My witnesses are pretty much in my pocket. They ready to come, but I don't like gambling with a life if the plea deal is good enough. You know, does my client have a good self defense argument? Yes, he does, a very good one. But the plea deal, 8 years, he's been sitting in jail almost 4 years waiting on this trial. You know, them numbers start making sense when you don't have to risk 40. But hey, man, it's not going to be my decision. It's going to be my client, and we'll see how that goes. So between those two, oh yeah, I got a bad, bad rape case. Oh, it's bad, really bad. But you know, we do what we do. My client demanding to represent itself. We'll see how it go with the judge say.
You gotta love those.
One thing I hate is sitting second chair to somebody who don't know what they doing. I did that one time. A client one time said he wanted to represent himself. The judge made me sit second chair. We got halfway through his first line of questioning, and the judge say, "Do you want to do this or do you want him to do this?" And the client looked at me and said, "I want him to do it." In the middle of the first witness, I take back over and I got an acquittal on the felony. He got convicted on the misdemeanor.
That's good. I'm glad you came on, man. It shined a light on, what we do, especially you doing it as a public defender. I find myself a lot of time defending guys who I know do public defense work that are good lawyers. I shouldn't have to defend them, but, in all honesty, there's so many that are bad or don't care that's where the stereotype comes from. But look, I'm always like, somebody asks me, I'm like, yeah, he's a good lawyer.
You know the other problem too, though, they overworked and underpaid. Our doctors are ridiculous, man. But my advice to anybody who wants to do public defender work, the best way to be a good public defender, you have to manage your calendar. You can't schedule 30 pre-trials on one day. It's gonna wear you out. You have to be a master of your calendar and your time. And public defender work can be easy if you can spread out the workload. But I'm guilty of it. You know, when I was doing all the cases, my workload was ridiculous, but I just could work. Now my workload is less, but I may be at court longer because my cases are more serious. But if you can master your calendar, public defender work would be a lot easier. And that's what I tell young public defenders. Don't overschedule. As long as you don't do that, you can manage the job. And they need to pay us more. You know, the system is made to protect the defendant, yet the state get all the resources. The Constitution was written for the people and to protect us. Yet we're underfunded and underpaid. Help it make sense. The state funds itself and then underfunds the very individuals that the Constitution is supposed to protect. But they fund themselves to take our rights away and lock us up.
I've never understood why. I think it goes without saying the job of a public defender is much more difficult than the job of a prosecutor. They're both public servants, why do the prosecutors get paid so much more? It's clearly not fair.
They get more everything, more resources. They got investigators at their fingertips. The police department helps them. The police department do the work for them. They not missing anything. Boy, I'm over here on the chitlin circuit putting together my trial and winning. Like some lawyers say, I just need a notepad. I just need it all up here. And I win. I hate losing. If you hate losing, you're going to do great legal work. They have to go together.